Hey everyone, this is Stacy Lake, and this is my special edition of Let's Talk Jackson. And this is the one where we are going to go specifically into the state's case against the Jackson County government. I want to say beforehand that while I am an attorney, this is not a legal opinion. I'm not one of the trial lawyers in this case. However, I am an attorney who specializes in civil litigation and commercial litigation. So I decided to have this live to go over some of the state's arguments and allegations pertaining to the 2023 property tax assessment. I'm going to warn everyone, this live is going to be very long, but I believe it's very worthwhile because what the state is alleging the Jackson County government did is very conniving. It's disgusting. It's manipulative. It's misleading. And if I would say if 50% of the facts that the state is arguing are true, then it's going to be very hard for the judge to rule in the Jackson County government's favor. And that's my opinion alone. Now let's start this presentation. And also, if there's anything wrong with my audio or visual, please let me know in the comments. And if you have any questions, please leave a comment on the video and I should receive it and I'll respond to any questions or comments throughout this live stream. Okay, now this is a brief summary of the state's main argument. They're arguing mostly through statutory law that the 2023 property tax assessments were unlawful for three main points. One, they failed to provide proper notice and inspections. Two, they coerced property owners to drop the appeals. And three, they failed to lawfully carry out their duties and obligations. And they present this argument in 9 counts against Jackson County. Count 1, violation of section 137.115.11, which is the failure to provide proper notice of physical inspection. Count 2, violation of sections 137.155, which is failure to perform required physical inspections. Count 3, violations of sections 137.180 and the other ones, which is denial of access to administrative remedies. Count 4, violations of sections 137 and 138, which is the dysfunctional administrative review process. Count 5, negligence for failure to provide proper notice of physical inspection. Count 6, negligence, failure to perform required physical inspections. Count 7, negligence for denial of access to administrative remedies. Count 8, negligence for dysfunctional administrative review process. And 9 is mandamus, which is basically the differences between the counts 1 through 4 and counts 5 through 8 is the first counts 1 through 4, they're trying to make a per se argument saying that on face of these statutes, they violated them as a matter of law, and therefore we must overturn the 2023 property tax assessments. But the count 5 through count 8 is more of a negligence argument saying that they had a duty to follow these procedures. And so it requires a higher burden than the negligence per se. But we're going to get into this. So the plaintiffs in the lawsuit, aka the people who filed the lawsuit, are the state of Missouri, specifically the Attorney General's office and the State Tax Commission. And the defendants in this lawsuit are the Jackson County legislators who were responsible for the assessment, the levy, equalization, and collection of all taxes. And they were also by law they were also responsible to providing a method or a system to facilitate the assessment, calculation, extension, and collection of taxes. We shouldn't get this twisted, okay? The Jackson County legislators were the ones that voted to provide Tyler Technologies the $17.9 million and authorize them to conduct this assessment. In the media is mostly focused on Frank White and Gail McCain Beatty, but we cannot forget the key role that the Jackson County legislature did in this assessment. The second defendant is, of course, the county executive, who our current county executive is Frank White. And this is because he was responsible for the administration of the affairs of Jackson County, and he has the power to correct errors in assessment and tax records. If you guys have been following me for a while, I stated that one of the powers of the county executive is that he can overturn the tax assessments if he finds that there is some sort of flaw or error with the process. But the problem with the 2023 tax assessment and the 2019 property tax assessment was that even though there were all these clear errors and flaws, Frank White refused to do his duty to overturn those assessments. Next, the county assessor, who our current county assessor is Gail McCain Beatty. This is because she was responsible for overseeing the assessment of real property in Jackson County. And also, the Jackson County Board of Equalization was brought in as a defendant, and they're responsible for hearing all the appeals from the county assessor's property valuation and correcting and adjusting assessments accordingly. And when we get to what the BOE did, it's what the state is alleging is crazy. So I hope you guys stay along for that. And finally, the final defendant is Tyler Technology, who is responsible for providing the mass appraisal services for the 2023 property tax assessment. Now, on June 27th is the first day of trial, and this is a bench trial for the Jackson County government. They are not putting Tyler Technologies on trial because Tyler Technologies requested a jury trial. And so their trial is scheduled to happen next year. Now, this is some background information about this case. So the county legislature granted Tyler Technologies a contract for $17.9 million to perform the services related to the 2023 assessment of real properties in Jackson County. And within this contract, they were supposed to conduct its exterior parcel by parcel reviews using a computer assist mass appraisal program called CAMA. And they used this system to arrive at accurate and fair property valuations. Tyler also promised, and this is the promises that they made to the county, that its assessments would be accurate, reliable, and exceed industry standards. The reason why the state is bringing this up in this argument is to show the duty that Tyler had, not only to the county, but also to the Jackson County residents. Now, Tyler Technology is able to get this contract because they advertised themselves to the Jackson County government as being proficient in providing mass appraisal services, that they were experts in data collection and property valuation, and that they had a history of helping entities deliver fair and equitable property valuations. And due to this, the Jackson County government made Tyler responsible for the data collection, which was used for the parcel by parcel review. They were also responsible for the physical inspections. They were responsible for the market value estimations, the informal reviews, and providing support to the Jackson County government during the formal appeal process with the Board of Equalization. And sometimes I will refer to the Board of Equalization as the BOE to shorten it, but BOE stands for the Board of Equalization. They also provided the Jackson County government with extensive image gathering. This is when they took photos of properties. They provided sales verification, and they were supposed to also provide information about neighborhood delineations. Now, this was the first red flag. Well, it wasn't really the first red flag, but this was one of the first official red flags of the 2023 property tax assessment when the state auditor brought out his report. So this was the state auditor's report that he made in December of 2023 when he reviewed the property tax assessments in Jackson County. So the Missouri State Auditor released the report about the Jackson County assessor and the assessment process. And the assessor in his parameters reviewed first whether the assessment department provided Jackson County property owners with notice of physical inspections for properties whose values increased by more than 15%. And second, whether the notices sent by the assessment department were timely and accurately described property owner rights relating to the inspections. This is because these are two requirements that are needed pursuant to state statute 137.115. These are the general findings of the state auditor. First, the auditor made the finding that the assessment department did not notify most property owners whose assessed valuations increased by more than 15%. The auditor found that the assessment department did not notify most of them, first in writing. Second, that a physical inspection was required. Two, did not provide clear written notice of the owner's rights relating to the physical inspection when conducting its parcel by parcel review. And then next, the auditor found that the notification was inaccurate and often untimely, and that the notification failed to comply with state statute 137.115, and that any residential real property assessed valuation increase that increased by over 15% was likely invalid. Now, this is where we're getting into the alleged evidence that the state is alleging that Jackson County actually committed. So this is what the state AG is stating that the Jackson County government did. So first, approximately 200,000 residential property valuations were increased by over 15% and therefore required a physical inspection. However, the assessment department only issued approximately 760 notice letters to residents before Tyler Technologies performed an exterior review of the property. And I'm going to break that down for you. So this is, and when I read this, I had to read this multiple times because this just blew my mind. This is the correct statutory process under Missouri law, chapter 137.115. And we're specifically looking at the paragraphs, section number 10 through 12. The assessment department was required to first do the parcel by parcel review. So the parcel by parcel review is when they're evaluating your property and determining whether what the price is going to be. Then, after the parcel by parcel review is completed, if the property is deemed to have an over 15% property or assessment value increase, the county is mandated to notify the owner of the exterior physical inspection. So Tyler Technologies goes out, does its parcel by parcel review. Then they're supposed to notify the property owner that A, their assessed value was going to increase by 15%, and B, that they would come back again for physical exterior inspection. Then after that notification, the exterior physical inspection occurs. And then you get the notice of increase letter, right? Now, if you remember what happened In 2019, we didn't have the door knockers, right? But in 2023, we did. And this is my experience with that process, which is the general experience of the Jackson County resident, where you had the people come to your house. They would knock on the door. They would either talk to you or leave that door hanger. And then after that door hanger, they would never come back, right? And then if you were one of the lucky ones, you would receive the assessment value notice probably around June 15-ish time. I received mine after the fact. And that would then notice you what your assessed value was and whether, what you would pay in property taxes that year, right? They're saying that entire process was completely incorrect. What should have happened, and we're going to get more into this, but what should have happened is when they were doing their parcel by parcel review, so when they were going from door to door, right? They were supposed to evaluate whether your property value was going to increase by over 15% or not. And then if that was supposed to happen, they were supposed to send you a letter stating that your property assessed valuation was going to increase by over 15% and that a physical inspection was required. And then after that, they were supposed to come back, conduct the physical inspection, and then provide you with the notice of increase letter, which this did not happen to the majority of Jackson County residents. And this still blows my mind. I had to read this statute around 10 to 15 times in order to make sure that I understood this correctly. But that's what the state is arguing. So I'm going to bring up this. This is the state auditor's report. And I'm going to go, so this right here, this is the assessment letter that was supposed to be given to you, that was supposed to notify you of the assessed value increase. And this was supposed to be provided to you at least 30 days before the official assessed value. And we're going to get into that as well. But the majority of Jackson County residents did not receive this letter. And I say that because I never received this letter either. But this letter, and this is different from the 2023 reassessment notice letter. But this letter was supposed to notify you that A, your assessed value was going to increase by over 15%, and B, that a physical inspection was required, and C, that if you wanted to, you can request an interior inspection of the premises in order to challenge the increase. And we're going to get into that this actual notice did not do those steps. And that's for the people, for the 760 people who received this notice before April 23rd. But let's get back to the slides, okay? Which, this is crazy. And if any of you are confused in here, please leave a comment and I'll try my best to explain this to you. So this is what they're alleging that Jackson County government allegedly did. They merged its physical inspection with its parcel by parcel review. Then they hung the door hanger on the owner's property. So they're using the parcel by parcel review and the physical inspection review as the same thing, even though that's not statutorily allowed. And then after that, they sent the statutorily required increase letter. So the state then argues that the door hanger violated 137.115 because the door hanger itself, the information that it provided, was insufficient. And this is first because the door hanger was just indicative of a parcel by parcel review and not the statutorily required noticed physical exterior review, and that the door hanger did not notice residents of their rights relating to the exterior inspection pursuant to statute 137.115. And let's go back to this. this is an example of the door hanger. And if you can see in here, you can tell that there is no notice, first off, that of what the Jackson County residents' rights were pursuant to this parcel by parcel review. There was no notification that a physical inspection was required. There was no notification of the Jackson County residents' rights to an interior inspection. And there was no notification that they were able to get this interior inspection with a 30-day notice. So you can see that this is like, according to the state, this clearly does not comply with the statute 137.115. Next, we asked the question about what about the 160 letters? And the 160 letters, let me clarify this. So, sorry, the 760 letters. So there's the 760 letters, then there's the 25% of the 200,000 parcels. I believe, this is my opinion, but it could be wrong, but I believe the 760 letters are the letters that were sent out in April. And then the 25% of the 200,000 parcels that increased by over 15% were the ones that were sent out on May 31st and June 15th. I could be wrong with this, but that's what I believe after reading this statute. But when they're talking about the 760 letters, they are talking about this specific letter right here, not about the actual 2023 reassessment notice. So they're saying that that specific letter was also insufficient because, one, it failed to state that a physical inspection was required by statute. Two, it failed to explain the owner's rights related to a physical inspection beyond the statement about the right to request the interior inspection. Because remember, the parcel by parcel, the state is arguing that the parcel by parcel review does not equate to a physical inspection. Three, that the letters were undated and did not provide sufficient time to request an interior inspection, which was supposed to be given within 30 days. Four, it did not include the percentage change in assessed valuation, which if we go back here, you see that this letter only pertains to the market value, right? It doesn't show what your how much your assessed value would increase. So they're saying that that's also to show that this is on face violating chapter 137.115. But let's continue. It's saying that it failed to show that if the owner requested an interior inspection, that the county was required to provide one. And then finally, a request for an interior inspection would include reviewing the exterior and interior inspection. And so on this one, the last one is basically saying that the request for interior inspection would also be a revaluation of the outside premises, the exterior valuation. And this is the state saying that the this request here, or this notice, should have provided all of that information. So this is this is what I was talking about here, the alleged evidence of what they were referring to. So this is also a massive point. So the state is alleging that the notification letters were due on April 23rd, 2023, and not on June 15th, 2023. And they make this argument in two different ways. They first state that this notification letter should have been provided on April 23rd, which it was not, right? And we're going to go on the second argument too, which I think is crazy as well, but we're going to get there. But the first one is they're referring to this notification letter. So only 25% of the 200,000 parcels were sent out assessment notifications. So this is like after April 23rd. So this was during the May 31st and May 15th mailing. And but of course, they said these notifications were insufficient. It notices that property owners, it notified, or sorry, the notices told property owners that they would only have the right to request an interior inspection if they had not made any improvements. And this on face is wrong because on the statute, even if you made an improvement to your property, you can still request an interior inspection as long as the value of the 15% increase excludes the value of those improvements. So the assessment department. So say if you had an addition onto your property, right? That increased your property's value by, let's just say, $10,000. And say your property beforehand was worth $90,000 and now it's worth $100,000 because of the add-on. They're stating that the assessment department was supposed to assess both the addition and the property. And if the assessed value of the original value increased by over 15%, so excluding the improvements, then you had the right to the interior inspection, but they did not state this properly on the notices. So they are alleging that Jackson County did not inform the majority of property owners of their rights until May 31st or May 15th, which this is, I mean, I believe this is 100% true because of the hearings that I heard during this whole entire crisis. And they also have the evidence about the mass mailings that went out that were on May 31st and June 15th. And what they are talking about here is now the 2023 reassessment notice. So they're stating that these notices were also insufficient because, first off, the notices stated that the property owners only had a right to request an interior inspection if they had not made any improvements, which we stated before is statutorily incorrect. Two, the property owners were not granted at least 30 days to notify the assessor of a request that an interior inspection to be performed during the physical inspection. Three, it did not provide enough time for property owners to schedule and receive an interior inspection and consider this information before the July 10th BOE deadline. And four, this argument applies to the July 31st extended BOE deadline as well. So this is how one of the ways I think that this could be interpreted is that when it comes to properties that were determined to be assessed by over 15%, one of the state's arguments is that those owners, specifically the owners of the properties whose assessment value increased by over 15%, should have been notified by April 23rd, because if they were notified by April 23rd, they could have had 30 days to request the interior inspection and then be able to consider whether to file an appeal with the BOE before the mandated deadline. And so that's one of the reasons why on face, this whole assessment was invalid and improper. Next, the state is alleging that Tyler Technologies did not perform all parcel by parcel reviews, even though the Jackson County government used these as proof of the physical inspections. Okay, so what the state is alleging first is that most of the parcel by parcel reviews were drive-bys where employees only took one photo, which this is specifically referred to in section 137.115, section 12, as being completely improper, right? The state is arguing that they needed to conduct, and when they're saying they mean Tyler Technologies and the Jackson County government needed to conduct an on-site personal observation and review all exterior proportions that an inspector has or may reasonably and lawfully gain external access to. And one of the ways that they're showing this is they're alleging that they have evidence that in at least one neighborhood there were several properties where the assessor reassessed the properties and valued them at over 15%. And when they looked at what Tyler Technologies did, they only took one photo of each house and they had an average of 41 seconds inspecting each property, which would violate this statute, because in this statute it specifically states that driving by a property or taking a physical photo does not mandate a physical inspection. The state is also alleging that Tyler Technologies did not provide proper notice of a physical inspection before doing the physical inspection. So this is where we're going back to the beginning, where I was telling you that they were supposed to first do the parcel by parcel review. Then they were supposed to provide notice to the homeowner that their property was going to increase by a valuation of over 15%. Then they were supposed to conduct the physical inspection, and then the property owner was supposed to be notified that what their 2023 assessed valuation was supposed to be, which they did not do for any of these properties. The evidence that they're relying upon this is, first, at one hearing for a property, the Tyler Technologies relied on a photo that was taken 5 years ago in order to argue for their property valuation that was above 15%. At another hearing, Tyler Technologies and the Jackson County government did not provide any evidence, and this includes photos or documentation, that they actually had a physical inspection at this property. And at another hearing, the state is alleging that a Tyler representative stated to a property owner that they refused a physical inspection, even though this property owner was never given notice of the property of the inspection. And one of the other key arguments that the state's arguing here is that Tyler Technologies failed to meet most of its deadlines, including its January 2023 deadline to complete final value estimates. And what this did was it made a snowball effect. So Tyler Technology was supposed to provide a lot of this information to the state in January 20, or into the state or to the county by January 2023. And that they weren't able to because they were still preparing this information. And because of this delay, it caused all of this confusion. And so the state's kind of taking this point as the kind of like as a snowball effect, that because Tyler Technology failed to do their duties, right? The duties that I stated at the beginning, where Tyler Technologies was supposed to, let's see. They promised that their assessments would be accurate, reliable, and exceed industry standards, okay? That they failed to do that. And because of their delay and because of their improper assessments, it caused this snowball effect of untimely notices getting sent out. And the notices themselves on face were also improper. So this is the state arguments in depth, okay? First, they are arguing that, and we went over this before, is that the Jackson County government failed to comply with state statute 137.115. And specifically, they're stating that defendants either did not notify all applicable real property owners of increases in the valuation or only provided notifications after the June 15th deadline. And the defendants did not consistently postmark notices that were received late. So, and this happened to me too. I'm going to go back here. The assessment notice, right? This is an example of an assessment notice that was sent out. My assessment notice didn't have a date on it. And this was also true with a lot of other people's assessment notices as well. And they're saying that that was also a deceptive practice, but that it should have been dated. So the physical inspections were required, when physical inspections were required. So this is specifically talking about properties whose property values increased by over 15%. They're stating that when these inspections were required, they didn't provide notice, or they didn't provide legally compliant or timely notice to the property owners. And in these notices, they also did not inform the property owners of their rights relating to physical inspections required by 137.115. And finally, they are arguing that defendants did not perform all necessary physical inspections of real property as required by 137.115 before increasing the value of a property by more than 15%. As I stated before, after they did their parcel by parcel review, the properties whose values exceeded, or whose increased assessed values increased by over 15%, should have been first notified by the county government that their property value was going to increase by over 15%. Then the county government was supposed to come back, perform the physical inspection, and then provide them with the assessed value notice, which of course did not happen. Second, the state is arguing that there was a violation of due process rights. And so what due process rights means is that when it comes to following laws, due process means that the system, in order to help provide you with relief, is working for everyone. So, like, for instance, if you have a speeding ticket, you have a right to see a judge, you have a right to a jury, right? That's due process. But in this case, because this case involves, first, you have to have an administrative review before you can actually file the private lawsuit against the Jackson County government. They're saying that that review process of A, getting notified of your rights, B, appealing to the BOE, then appealing to the State Tax Commission in order to finally get your right to sue the Jackson County government, was violated because of the lack of efficient administrative relief and a dysfunctional appeals process. So an ineffective administrative relief as well. So their first argument here is that the Jackson County government denied the means to the Jackson County people to file an appeal. And that this, what the Jackson County government did in denying the means to file the appeal violated their due process rights. And the evidence that they're using to prove this is, first, they're saying that the Jackson County government systematically failed to properly and timely provide notice to the Jackson County property owners with the statutorily required notice of the valuation increases, and that the property owners received such notices after the June 15th deadline. And thus, because they received these notices, and what I'm telling you is these are the notices stating that not only was your property value increased by over 15%, but you also have a right to an interior inspection. Because of these notices were received after June 15th, this hindered their ability to file an appeal. And we're going to get more in depth into that point. But second, they state that the website was riddled with technical issues, which, if we remember, on the day when we all received our notices, what happened? The Jackson County website dealing with uploading information or receiving information about the property assessment process, it went down, right, for days. And this goes into their next point, that the property owners would wait for hours on the telephone without receiving an answer, or would be disconnected while waiting in the queue. Now, this is specifically important because with a lot of our Jackson County residents are elderly people who may not know how to use a computer or may not have access to a computer. And so they would call into the Jackson County government in order to receive information about the assessment process and also about their appeal process. But in this case, the state is alleging that they did not have this right because either they would be waiting on the phone for hours, their phone call would be dropped, or even after waiting for hours, they would still not receive adequate information about the assessment process or about why their properties increased over 15% in assessed valuation. So next, the county government specifically details, or sorry, not the county government, the state AG's office and the state tax commission specifically details the county's unfair tactics that they used during this whole property tax or property assessment in 2023. First, the state is alleging that the Jackson County government undermined the option to directly appeal to the state tax commission. And I'm going to go over to this, but I just want to say I find this whole thing conniving, if this is true. Okay. So the state AG's argument is saying that in Jackson County government's argument to the Supreme Court, the county admitted to a failure on their part to provide timely notice, but states this failure did not have the effect of denying property owners access to administrative relief because the property owners could have appealed directly to the state tax commission. So what they're stating in this argument is they're stating that, yes, we did fail in providing proper notice. However, this did not prevent or this did not violate the Jackson County residents' due process rights because they could have appealed to the state tax commission. Therefore, they had other options in order to fulfill this process. However, the Missouri AG and the state tax commission argues that after this argument, the assessor still sought the dismissal of hundreds of appeals to the state tax commission based on the argument that the property owner must have brought the appeal to the BOE first and receive a decision before the state tax commission could have jurisdiction over a property owner's appeal. Okay, so just to simply summarize this, Jackson County government goes to the state, argues, we failed to properly notify these individuals. However, our failure wasn't critical. It did not violate their due process rights because they could have directly appealed to the BOE or to the state tax commission and received due process. And the Supreme Court of Missouri was like, okay. Then afterwards, they tried to dismiss hundreds of appeals stating that they should have not directly appealed to the state tax commission, but should have appealed to the Board of Equalization first, which is a contradiction of the argument that they made to the Supreme Court of Missouri. Okay. And they use this argument on over 200 different appeals. So then property owners, the state's alleging that it was a Jackson County government tactic to make property owners unable to receive a hearing with a BOE. And this is the evidence that they're alleging that happened. So on December 19th, 2023, the BOE started to postpone the BOE hearing, so the Board of Equalization hearings. Since then, the Board of Equalization has conducted either no hearings or a minimal amount of hearings since December 26, 2023. And this is important because 14,416 hearings have yet been resolved, right? And let's take this a step back. Property owners are supposed to first appeal to the BOE, and then after the BOE makes their findings, that's when they're able to usually appeal to the state tax commission, right? The state AG's office is saying that even these people who properly filed appeals to the Board of Equalization are unable to have the Board of Equalization hear their cases because the Board of Equalization right now isn't hearing cases. And they're stating that thousands of these hearings will remain unresolved by the end of the Board of Equalization's final hearing date of March 30th, 2024. Next, the state of Missouri and the state tax commission make the argument that property owners who received a formal or informal hearings did not receive fair and effective administrative review. And they state that the county made it systematically impossible for Jackson County property owners to be treated fair and to be treated to a fair and effective administrative review. And the way that they're proving this is, first, they say that the review by the county through Tyler Technology starts with the assumption that the assessor's valuation is correct without the assessor ever having to prove the assessed valuation was legitimate. Now, I'm going to break this down. So now we're talking about the informal and formal review. So I don't know if you're aware of this, but say your property values increased by over 15%. The Jackson County government said, hey, you can appeal to the BOE, but also you can have an informal review, right? Which is a review with usually a Tyler Technologies employee who evaluates your property and makes an overall determination as to whether or not the originally assessed value was correct, right? So they're saying that, and I'm trying to break this down, and I know I have this in later slides, but I'm going to bring this up now. When you go to the BOE, there's a thing in law called a burden that you have to overcome. Like some laws, you're required to overcome a burden. When you first go to the BOE, the burden is on the assessor to prove that their valuations are correct. And so the county assessor has to provide information that their assessed value was done correct pursuant to the statutes, okay? Then after they meet that burden, it's on the property owner's shoulders then to prove that the assessed value was incorrect. So what this means is, first, the assessor has to prove that their assessed value met legal standards. And if they do not meet that burden, the BOE is supposed to drop their increase in valuation. However, once the BOE determines that they met that valuation, then it's on the property owner to provide evidence showing otherwise, okay? They're saying that during these informal reviews, the Tyler Technology employees or volunteers or the people that were doing these informal reviews, they were holding themselves or they were basically saying that the original assessed value was correct and that the property owners had to prove that that the assessor's value was incorrect, and therefore what the state is arguing is that that was statutorily incorrect, because at the BOE level, it's on the assessor's shoulders. The assessor has the burden to prove that their assessed valuation was statutorily correct before the property owner was to provide any information that the assessor's value was incorrect. And so because the Tyler Technology and the Jackson County employees who conducted these informal reviews had this mindset that the assessor's value was correct, this actually pressured property owners and caused them to accept illegitimate assessment valuations. And this is because the county and Tyler did not make it consistently clear to property owners that the informal review was optional, did not specifically detail the difference between the informal review and the formal review, which the formal review would be the Board of Equalization review, and that they did not inform property owners of their rights. And they state that Tyler Technologies, their employees and representatives, were untrained in providing property owners with information of their due process protections. And this specifically goes into that burden that the assessor's value at this stage, and when I say at this stage, I mean at the informal stage and at the Board of Equalization stage, they have the burden of first showing, they were supposed to show to the property owners that pursuant to the statutes, their assessed increased value of over 15% complied with the statutes first, before the property owner had to present any evidence, which they clearly did not do. So next, I have this specific section here. It's 138.060.1, and it states, in such county or city, in the event a physical inspection of the subject property, which, remember, as I stated before, if your property's value increased, or their assessed value increased by over 15%, the Jackson County government was statutorily required to provide you with a physical inspection. So this is only to people whose property values increased by over 15%. The assessor shall have the burden to establish the manner in which the physical inspection was performed, and shall have the burden to prove the physical inspection was performed in accordance with section 137.115. The state argues that defendants never disclosed to property owners whether a physical inspection was conducted, and therefore depriving them of the ability to prevail as a matter of law, and that defendants, so this is the Jackson County government, insisted that the physical inspections were completed in compliance with the statutory requirements without providing any evidence to support such a claim. Okay? And this is, and we're going to get into this. This is why I believe, and I'm taking a step back. Again, this is not a legal opinion. This is just my opinion on my own. This is why I believe that the State Tax Commission is involved, because you're supposed to have this burden of proof at the BOE and below stage. That the BOE is supposed to first hear from the assessor, and they're supposed to provide evidence that their assessed value met the standards of the statute, that is statutorily, that they complied with the statute. So they provided proper notice, that the tools that they used to evaluate the property that gave them property valuation of over 15% were proper, and that notice was given properly, right? First, before the property owner is supposed to say anything. But this did not happen. And so because of that, cases that were going to the State Tax Commission were kind of corrupt, and we're going to get into that. and then we're going to get into that later on, but let's just continue on to the county unfair tactics. So the states are also arguing that the Jackson County government pressured owners to accept the values offered to them at this level, because they would tell them that if they do not accept the value offered, then that they're at risk of receiving a higher even a higher a higher assessed valuation at the BOE, right? And what that means is that even if on face the assessed value, or the assessed value was invalid because the assessor could not prove that a physical inspection was completed or that they provided proper notice, so that the assessed value was invalid as a matter of law, the property owners would still be pressured to settle because they would not know this. So this means that if these people who went through the informal inspection, and also I believe that went through the BOE inspection, if they were not notified of this burden, of this requirement for the assessment department or the assessor to prove that the assessor actually complied with law before they have to present any evidence, then they would settle a case because they did not, they were in fear of their valuation increasing, when in fact their case would have been dismissed because the assessor would not be able to meet their burden to have their increased valuation enforceable under law. And if you're confused by this, please leave questions in the comments, and I will get to them. Next, the state is arguing that the Jackson County, or that all the defendants made the physical conditions of seeking the informal review virtually unbearable. And this is because, first, property owners were forced to wait upwards of 5 hours in person for an informal review beyond the scheduled appointment time. Second, property owners found themselves stranded without food or water except for the drinking fountain water or their essential medical devices or treatment, which is huge because we're talking about the elderly. If they're showing up on time to an informal review and they have to take medicine within 3 hours, they probably didn't bring their medicine with them, and because they didn't know that they're going to be waiting in line up to 5 hours after their appointment time was supposed to happen. Next, they say that property owners that gave into the pressure signed a stipulation that signed away their administrative remedies, meaning they lost the ability to further appeal the assessed value for their property. So we have to put ourselves into the people who went through the informal review process in their shoes, right? You filed an appeal, you go to the formal review, you get there on time, but then you have to wait 5 hours in a room for the informal appeal to happen, where the assessor is basically telling you that you have to convince them that their assessed value is incorrect, which is already improper under the law, because they have to show that their assessed valuation of your property was actually compliant with the statutes, which they never did, right? But you wait 5 hours. You don't have access to food. You only have access to fountain drinking water, and you don't have access to your medication, and you're in uncomfortable chairs. If you have a chair, all these elements probably forced a lot of people to sign these stipulations because they just didn't want to continue with the process because it was too burdensome. And because this coercion, they're saying that these factors induce them to sign these stipulations. That means that they waived their rights to appeal further, and that they lost the ability to appeal to the BOE or to the state tax commission, even if their valuation was on face, even if their assessed valuation was illegal pursuant to the statute. So this also goes into the BOE side. So now this is specifically towards what the BOE did incorrectly. And so the state is alleging that the Board of Equalization placed the burden of proof on property owners to prove their cases despite the statutory requirement of the assessor to prove their assessed valuation pursuant to statute 138.060. The Board of Equalization did not require the assessor to prove that the assessor conducted legally compliant physical inspections. And this was troublesome because at the state tax commission level, the state tax commission believes that the BOE's assessment is correct and the burden shifts to the property owners. If the burden of proof was improperly placed on the property owners in the BOE stage, then the BOE's decision and presumption is adversely impacted and prejudicial to the property owners. So what this is saying is, like I stated before, at the BOE stage, it is on the assessor to prove that their assessment was legal and followed all the statutory requirements under Missouri law. But since at the BOE stage, they actually reversed it where they said, no, instead of the burden being on the assessor, the burden is in fact on the property owner. That this made all of the cases decided by the BOE improper because it adversarially impacted the cases and was prejudicial to the property owner, since if the burden was reversed, and when I say reversed, I mean was correctly applied, where the assessor had to first prove that their valuations were correct pursuant to the statute. And then once they met this burden, the property owners would have to put on evidence. That means that if in the BOE stage, if they were unable to meet this burden, then a lot of those cases would have been dismissed due to lack of evidence or lack to meet that burden, which did not happen. And so when you go to the state tax commission level, the state tax commission is going to use the BOE's decision as a decision against you. They're basically going to say the BOE's decision is correct, and therefore you need to prove that what the BOE and what the assessor said was incorrect, right? And they have this process because, again, at the BOE stage, the assessor first has to overcome that burden to prove to the BOE that the assessment was done properly. And because this process was violated, this impacted negatively all the appeals that were given to the state tax commission. And finally, the state argues that this inconsistent application in rules and process during the administrative review process violated, of course, the Jackson County prosecutor's rights. And it's hard to argue against that when you're looking at the state's allegations. The state concludes by saying that this process was done to wear down property owners so that their abilities to pursue the administrative remedies were severely diminished. It encouraged property owners to give up and to not pursue their appeals because defendants led them to believe that such evidence were futile. So this is the harm side of the case that the state is alleging that the Jackson County government committed against the people of Jackson County. So first, they're stating that the Jackson County government, the Board of Equalization, the Jackson County legislator, the county tax assessor, and of course the county executive harmed property owners' rights, and these are their constitutional rights and their statutory rights. First, they have the right not to be taxed based on unlawful property valuations. And of course, they're referring to the statutes that we noted before, specifically 137.115 and 138.060. Second, in Article 10 of the Missouri Constitution are the provisions specifically relating to our rights when it comes to taxation. But on Article 10, Section 22 of the Missouri Constitution, it specifically prohibits counties from levying any tax that's not authorized by law. And Section 10, Article 23 of the Missouri Constitution states that a taxpayer has standing to bring an action in circuit court to enforce provisions 16 through 12 of 16 through 22 of Article 10. And so, in layman's term, the state is alleging that the Jackson County government harmed Jackson County property owners by having them pay taxes on illegally increased assessments without the opportunity for meaningful administrative relief, and that they provided unexpected tax burdens. And on the unexpected tax burdens, they specifically go into elderly living on fixed incomes that are unable to account for the increase in taxations or the taxes that they have to pay to the county each month. The property owners that provide housing to tenants that leads to increased rents to those tenants that are living in those properties. Commercial property owners and their lessees and their customers, basically saying that, like, say you have a store, or say you own a building with 5 businesses inside, and because of the increased tax burden, not only do you have to increase rents to the lessees, but also that trickles down to the customers of the people that these businesses are providing services to, because they'll have to increase their prices in order to be able to pay off the increased tax burden. And finally, potential property owners that are unable to afford a property because of the tax burden. So people who are looking for houses, once they find the increased tax burden and they're unable to, for instance, get a mortgage because they're unable to pay the monthly payments due to the tax burden, they were also potentially harmed too, even though they don't have a house in Jackson County yet. And finally, they're saying that the Jackson County property owners were harmed due to the dysfunctional process created by defendants that we already went into in depth. So the state then makes an argument about how the state's interest and the general welfare is at stake in this case. And I'm going to go through their main arguments, but they're basically stating that if the courts don't do anything because anything due to the illegality of the Jackson County government's process regarding the 2023 property tax assessments, then people are going to lose faith in the laws and in Missouri's laws and the constitutions in Missouri. And so that's going to affect the people's overall general welfare, their trust in the system. And so first, the state says that they have an interest in ensuring that there is a public right to the enforcement of laws within the state. Second, the state interest extends to preserving the integrity and reputation of the state tax system. If one county is allowed to violate the laws, then it sends the message to other counties to violate the laws. And this is, I think, is a great point. Number 3 is a great summation as to why this would affect the general welfare, because if the people are shown that if the Jackson County government can get away with this, they can do whatever they want, they're above the law, then what's going to stop Cass County from doing this? What's going to stop Clay? What's going to stop Platte? Next, the state says that the state has an interest in protecting Missourians from incurring harms through the imposition of an undue tax burden, and that this interest is also reflected in Article 10, Section 14 of the Missouri Constitution, and it is statutorily imposed responsibility to supervise the assessing officers of the state and county board of equalization, as well as the laws concerning the general property tax. Basically saying that there's an interest here in order to make sure that there is a person who's overseeing the Jackson County government and the Board of Equalization to make sure that they're actually complying with the laws. So then we finally have to ask the question, what are the remedies and relief? What is the state asking the Jackson County Circuit Court judge to do in order to amend the harm that the Jackson County government caused? First, they're stating, and this isn't all the remedies and relief that they're asking for. These are the ones that I put here that are the most important. First, they're stating that any increase in assessed valuation of implicated real properties is void. So basically what this is saying is first, they're requesting the judge to recall all the properties that were assessed in 2023 back to their assessed valuations in 2022. Next, they are arguing that preliminary and permanent injunctive relief against county defendants in collecting and or levying any property tax based on an increase in assessed value. What this basically says is they're basically asking the court to prevent the Jackson County government in collecting taxes or putting any levies or holds on properties titles based on their 2023 valuation. Okay. Next, they're asking for preliminary and permanent injunctive relief, limiting county defendants' real property assessed valuations to the values arrived through the previous assessment, which is basically the point number 2 is they're asking the court to prevent the Jackson County government to enforce the values that were given in 2023. Next, they're asking an order limiting the assessed valuation increases of residential real properties to like a 15% cap, which I don't think, number 4, I don't think that's the judge is actually going, if the judge is going to provide any relief, I don't think the judge would provide number 4, because there's an argument there that, you know, hey, if these properties were assessed incorrectly, then how can they prove that their valuation should have increased by even that 15%? Next, they're asking for preliminary and permanent injunctive relief, limiting assessed valuation increases of residential real properties from the 2023 assessment to no more than 15%. And as I said before, I don't think this is a realistic expectation because of the fact that the court might find that also improper, because if there were all these improper evaluations, and how are we going to prove that the 15% valuation was also statutorily correct? Next, the state is asking for an order declaring the county defendant's duties under applicable statutes, which is kind of like, judge, you need to tell the county what they specifically need to do in order for this to never happen again. And finally, that the court uses its equitable powers to award the taxpayers who did not pay their tax bills by December 31st, 2023, a refund of overpayment, and for penalties and interest, apply for late payment or non-payment or other relief as the court deems just and proper. So if we have those people who paid under protest or did not pay their property taxes at all because they didn't agree with the property tax assessment, what the state AG is arguing here is that the court should issue an order to the Jackson County government, basically waiving any penalties that created, like any penalties when it came to untimely payment or or any interest that was applied due to the fact that their payment was untimely should all be waived, which is something that the judge can do. And that's actually my last slide. Now, what I think is most likely, I mean, look, what I think, if the judge actually agrees with the state AG, I honestly believe that the judge, there is a chance here the judge might void the 2023 property tax assessments. Like, I think that is a very likely situation that may come out of this case. Because, you know, the state's argument that the parcel by parcel review is separate from the actual physical inspection review, if the judge agrees that that is true, then we know that the Jackson County government did not give a physical inspection as required by 137.115, meaning that they were first to provide notice of the increase and then provide the physical inspection. I mean, at least with my property, they did not provide that notice to. And according to the state AG's office, it was only either 760 properties or 25% of the 200,000 properties. So that still states that a majority, like it's clearly shown that a majority of these properties weren't provided statutory notice pursuant to statute 137.115, which is very problematic. And so yeah, I think, you know, if the court takes the AG's side, oops, sorry about that. If the court if the court takes the AG's side, I honestly believe that they will actually win on this. So, yeah. Anyways, if anybody has any questions, please let me know. But I don't see any questions here. So I'm just going to go off. Anyways, thank you for coming out to this live. I hope you had a fun time. I did as well. And if you have any further questions, please let me know. See you.